talk you through each particular slide, which has some meaning to it. And on the first slide, excuse my doggy in the background, on the first slide, we've got a number of different registrations here. First thing I'd like to put in is the letter C means copyright, and R means registered design and registered trademark. And you'll see I've registered a phrase ahead of a curve. It's very good to actually register common phrases. Excuse my doggy in the background, but can I just go back and collect my dog because she's going to start screaming. I'll be a sec.
Screaming dog.
Why do we do this? Why do we have these animals? But they give us so much pleasure as well. But I do sit there and think how much time and energy I put into my cats, and I just think they give me nothing back, and yet they give me everything.
They give you everything back
And nothing.
This is not
noisy
your
one.
puppy. This is another dog, isn't it? We met your puppy the other day.
We've got 4 of them, and they're all Jack Russells, so they have very large characters. Coming back, so ahead of a curve, that can be that I registered that, so I actually own that phrase, and I was pleased with that because it's very similar to ahead of the curve, which is a common phrase. But by making a small difference, I've got sufficient distinction in that phrase to own it. So do consider mottos, slogans, small phrases which have links with common use, because it can be useful to actually acquire those for branding purposes. Second point is I've also registered my domain name, Consult SMP. That gives me, consequentially, ownership of derivatives. So I don't need to spend money buying a number of other domain names. I actually own the domain .com and .co.uk, but there are obviously hundreds of other derivations around the world, which I don't need to actually buy because I have automatic ownership of them by registering Consult SMP. And that's a big saving, but it also stops other people from buying those domains and being confused with my brand and losing inquiries that should be coming to me. More commonly, of course, we do register logos, and Jill has registered the ORB logo, and I've also registered Strategic Management Partners logo. I can't register the word Strategic Management Partners, just as Jill can't register Responsible Business Standard. But if you link your word names, your brand names, with a suitable, unique, distinct logo, you can own it as a trademark. So bear in mind that trademarks are very flexible and can save a lot of money and can protect you from unscrupulous people who want to buy Google AdWords or want to buy similar domain names in order to take your inquiries. Big saving and a big risk protection. So other reasons to register a domain name besides not losing inquiries does improve your search engine optimization. So if you Google Strategic Management Partners, you will find me, little old me, working from a bedroom at home as a sole director on the front page of Google with Strategic Management Partners, because in part, my trademark ownership is protecting me and stopping others from using that. Domain name costs we've covered, but it also indicates to third parties, which is particularly important if for ESG tendering purposes, you want to link up with larger supply chains. You're actually showing them that you are a responsible business. And indeed, Jill's standards for responsible business include the recommendation that IP and trademarks are indeed protected. But a much bigger opportunity lies in licensing. And indeed, one of my many licensing clients in training and consultancy, freelance trainer based locally in Sussex, licensing content on how to breathe effectively, actually has 100 licensees in North America, each paying him £2,000 a year on average for the use of his content. So that's a licensing income of £200,000 a year, because he's been able, through me, to protect his not only trademark, but also register the designs of his training. Design registration is much more important than copyright protection. Copyright infringement is usually seen as a civil infringement. Design infringement is usually seen as a criminal infringement. So there's much bigger teeth to protecting content through design registration. And indeed, overall, if you own a trademark, then you've gone through the search process. You've actually checked if other people have not got a similar brand. If they have got a similar brand and you're using it, or indeed you're applying for a trademark, they will be automatically informed by the Intellectual Property Office, and that may well lead to an infringement claim. And those are very expensive. To emphasize the expense, at the bottom of this slide, we've got an indication that indeed one of my contacts in the world of training, unfortunately, using a brand logo that was similar, not the same, as another training company, and he was asked to pay £150,000 infringement costs. So he had to close that business and rebrand. So even for small firms, this is a very significant issue. If you do not check in advance on who owns what, whether it's registered or unregistered, you are going to run the risk of this level of claim. And it's very widespread in the small enterprise market, as you see from these numbers. The reason for this is because most small enterprises are unaware of the frequency and the level of risk, because they don't read about it in the news. And the reason they don't read is that infringement cases, which are very significant, very rarely get publicized because they are settled out of court and under non-disclosure agreements. So 99% of infringement cases where we've got this level of cost are not reported, and that leaves the small enterprise market relatively ignorant of the frequency and the high risk this problem has. So be aware, risks are out there, and ignorance is no protection. The uniqueness of the badge, it's renewable for life. Always use the R, which indicates it's registered. TM indicates it is not registered. Yeah. So by using the TM mark, you're simply advertising the risk that you have. We have a bigger problem, as indeed, Mitali, you've already mentioned earlier, and that is, and Tracy, you've mentioned this as well, most designers are unaware of the importance of trademark and design protection and registration. And so they fail to pass on the right advice often to their clients. And we've just mentioned the issue of consequential liability to business advisors of all sorts, whether they be designers, marketeers, responsible business advisors, or indeed accountants and law firms. Unless they advise clients of the knowledge that they have of IP risks, they may well be countersued by not passing that information on. So what can you register? Names, logos, slogans, shapes, pictures, graphs, processes. Processes in particular can be registered as designs. Well worth considering if you're in the field of consultancy or training and you are providing advice on process improvement. If those process improvements are unique, they could be registered potentially as designs. Going back just for a moment to domain names, it was in the news not too long ago, Donald Trump seeking $100,000 for 4 domain names that were being used by third parties because he registered the trademarks and he's been running, or his lawyers have been chasing those trademark users who have bought the domain names online from domain name sellers, unaware that they infringed his own trademarks. And the judges have ruled that users of those domain names must now pay him £32,000 each, $32,000 each in damages. So again, domain name checking, really important. It's often missed, especially by law firms and IP attorneys, but it is an important issue if your domain name differs from your trading name. So how do we get around this? Searching is the #1 activity to check who owns what, whether it's registered or unregistered, because even unregistered trademark owners have rights. And if you infringe, an unregistered trademark owner has been using that branding before yourself, they have prior rights, and they may have a case for what we call passing off. So they can still sue others, even if they have not registered their branding. What are application fees? Well, to start, the IPO charge £170 to register and protect in one class. That's one trading activity. But if you're a trainer or a consultant or a designer, you may want to register 2 classes. That's simply because there are different classes for training and consultancy. Design is even lower cost, more affordable. A single design can be registered for £50 with the IPO fee. And if you want to register 10, it'll be £70, 20, £90, 50 designs, £150. Really good value. And the reason it's good value is because the UK government want to encourage people to register designs to protect them. And I'll be showing some examples of lack of protection in a moment. Try not to do too much yourself in terms of applications, because 1 in 10 applications are rejected because they're incomplete or the inventive criteria, in other words, the distinction is not met, or they haven't done a proper search. And it's not sufficient to search the exact brand names. You have to search derivations. You have to search other registers outside the UK as well. So bear in mind that searching does require a trained operator, someone who's certified in IP advice, and it's best for them to advise you on that side. There are lots of different classifications as well, and that's where another area goes wrong for the DIYers. Some examples. Here we have a well-known example of the Trunky, the original creator of the Trunky on the right-hand side here. Had his IP attorney register the Trunky as a design, but the IP attorney failed to register derivations of that design. Now, to do that would have only cost them £70. But by failing to do that, someone else has come up with a derivation which is not similar in the eyes of the IP judges, and they've created and registered their own design, manufactured it abroad outside of the UK, and have subsequently taken about £6 million worth of revenue from the original designer. So one could actually say that for the sake of saving £70, they have lost £6 million of revenue to another company. Well, it's important to consider derivations as well. Another example, very common in the fashion industry, especially UK fashion traders, but UK fashion designers are often freelancers, highly, creative people. And once their products go online, they're often copied. Here we have pretty much a copycat of products selling for 300 and some pounds, now being retailed at under £50. And all it would have cost was to register that as a design for £50 to prevent copycats coming on stream. Even Companies House is not safe for you. Here we've got an example of Heston Blumenthal, a celebrity chef, finding that fake companies, similar to his company names, were being set up on Companies House, and they were then calling on suppliers to provide goods and services and taking money and then failing to complete their trading. So they were Phoenix companies, as we call them. It's a very common problem. To give you an example, if Strategic Management Partners Limited, LTD, was registered, someone else could register Strategic Management Partners with a full LIMITED. Perfectly legal on Companies House. And the problem is Companies House is not an automatic check with the IP registered. So this has been a common problem. They're trying to now tighten up on company names, but it's still going to be an issue. Another reason why searching is very important on Companies House. Another designer case, in this instance, the UK designer Tom Dixon has lost more than £1 billion to copycat versions, £1 billion. Because he's failed to recognize the importance of protection through design. He does now, of course, but he's had to discount an awful lot of his products as a direct result of that ignorance. And copycats are now being created by the very large platform retailers like Amazon, eBay, Facebook. And if you're not registering your names or designs, they will pick up who is selling well, and they will often replicate what their customers are doing. Big problem. Not well publicized, but it's a massive problem. And even on LinkedIn, again, the same issue arises. If someone is doing well as a business on LinkedIn, people will take notice and take advantage of lack of registration. Recent example at the end of last year, this young lady was selling a very, very nice design for advent calendars. She failed to register that picture as a design, would have cost her £50. And as you can see, 900 fake listings appeared within 3 months online, mainly from China. And what they were doing, they were setting up fake websites with that copy of the design. And instead of asking people to pay £150, which was her charge, a very good product, by the way, even for £150, they were asking people to pay £49. They received the money and then closed the account without sending anything back. She's learnt her lesson. She's now taking issue through the press because it's cost her an awful lot of lost revenue. AI is a much bigger problem than people realize. Without registering your content, trademarks and designs, AI can pick it up and share it, especially as it does not source where it picked information up from. The good news is that anything that appears on AI, even if people think it's original, it cannot be protected as original, whether it's trademark or designs, because it's created by a computer. And the rules say that computer-created content cannot be registered. It has to be created by a human being. Having said that, people are losing a lot of money. So having that extra R in a circle to indicate that this is registered as a design gives you teeth to chase down the copycats who may be using AI to scoop your stuff up. Even book authors or bloggers or article writers have a problem. Here on the left, one of my clients, Neil Lawton, he is an adventure explorer. He's climbed Everest and done lots of other interesting things. He wrote a book, published it last year, called Adventureholic. But we've registered that title as a trademark. And we've registered his front cover as a design. Because what's happening in the book market is that other people are copying a nice title and putting content through Amazon as if they are the original title author. People are then paying them for rubbish content, not realizing that it's not the original title author. So we've got the example of Hyperholic here that's been copycatted a few times, and the original author is losing out. And of course, this does affect their reputation in the marketplace. So if you're thinking of a book coming out, then do please consider protecting either the title or your front cover, or both. You're using a name which is already used and similar, not the same, to a well-known brand, you could be creating a problem. Case just last year published, a Yorkshire sole trader, who was jet washing driveways, used the trade name Easy Jet Wash. And he was sued successfully by EasyJet for using a similar branding, even if he wasn't involved in any way with the airline market, because it's a well-known brand. He actually then had to rebrand. He was fined a significant amount, but this is a salutary tale for other small traders. In the bottom case, I went to a local market trading location, open stall, bought a bottle of rum. Really nice rum it was too, but it had a trademark very similar to the Harrods H. I have warned the manufacturer to then subsequently make changes to that mark, but he could have had problems with the whole of his stock using that H. There's a bigger example, and just to emphasize, it doesn't have to be the same logo that you're using, just something similar in the same trading class, in the same trading activity. So, big company had to pay a smaller company £240,000 for infringing that logo. Quite a lot of money. Good news, well, I've mentioned licensing. Please consider, if you know of any freelancers, small traders who want or could license their products or their services, their content, licensing is a great way to accelerate growth, not just outside of their location nationally, but also internationally. So it can work out. It will cost perhaps up to £1,000 to go through the protections, but for the income potential, this could well be worthwhile. It's another on one of my clients. It's a growth coach, coaching service. Here's an example of the design that they have registered. And we've registered a number of their designs from the appearance of the designs in their book. So they published a book with a variety of designs, and we have now got these protected as registered designs. An interesting case, this one. If you're a designer and you're selling your designs to the corporate market, or indeed public sector like the NHS, please consider licensing that design rather than actually assigning all the IP rights to the client. Because if you license it instead of selling it, you may well be in for bumper profits downstream. In this instance, the designer of the Bratz doll charged the client £500 to buy the design. Subsequently, the client sued another big company who was using a similar design, and they won £1 billion. Yeah, the original designer got nothing back, but if they had licensed that product, they would have got a big share of that £1 billion. So here's an interesting example of what designers should be considering. They look at licensing their designs instead of just selling them on a one-off basis. If you're protecting your IP, try and do what I do, put it on your website. This is a screenshot of my home page. At the bottom of my home page, I put in my IP certificates, because showing and advertising your IP protections can make a difference and deter others. But it also sends a strong signal if you're supplying into the larger supply chain, whether it's public or private sector. They like to see what you're protecting as well, because they don't want to run the risk of you losing your business through a single infringement. Finally, a couple of simple examples. I spotted this van, Spruce Spring Clean. That's a rather nice name, isn't it? The only problem is that it actually is very similar to Bruce Springsteen. And the reality is that they could be sued for infringement because the original Bruce Springsteen is a very well-known trademark now, and it is registered and protected, has been since 2013. So this is a risk not worth taking. And more recently, I came across Sherlock Holmes. That's a locksmith in Hastings. Got the branding all sorted, and you can see they've got a picture of Sherlock Holmes at the top right and on the bottom on the right-hand side. The problem is this is a registered trademark. When you register the words, you have automatic right over anyone displaying those words in a logo. And indeed, in this case, they've not just registered and protected the word, they've done that with the logo on the shadow face of Sherlock. So again, here we got an example of someone going out into the marketplace, advertising very publicly, and someone's going to catch on eventually, because IP attorneys are constantly looking for infringement cases on a proactive basis. So my final message is, don't put your head in the sand. Try and do the searches first. Very important. And if you'd like further advice and information, I'm freely able to give this on my website and through lots of free blogs and articles and events like today. So thank you to you, Jill, for helping put this together for a small but very important audience. And I'm happy to take questions as well.